Good morning. Доброго ранку, шановні колеги. Для українських глядачів прошу переключити нижня панель, там є переклад. Глобус намальований, переключіться, будь ласка, на український канал. У нас буде паралельний синхронний переклад на українську, будь ласка, а далі у нас захід проходить англійською мовою. Good morning, everyone. So today we have our next event from our series of digital economy and social justice that's supported by Clark Foundation for Legal Education, Ukrainian National Association of Insolvency Agent, Association of Private Enforcement Officers of Ukraine, and National Bar Association of Ukraine, and Institution of Economical Legal Research of National Academy of Science. So today we are collect all speakers of our next topic. It's asset trust and in insolvency and recovery procedure. So our first welcome speaker will be chair of Association of Private Enforcement Officer of Ukraine, Оксана Русецька. Оксана, please, welcome.
Добрий день, шановні колеги, я вас вітаю. Сьогодні, на мій погляд, один з найважливіших заходів для представників юридичної спільноти України, як для адвокатів, так і для виконавців, так і, в принципі, до будь-яких представників нашої спільноти, оскільки тема транскордонного виконання стала неймовірно актуальною, особливо в період Великої війни в Україні. Оскільки ми маємо по різним даним різну кількість переселенців, але в будь-якому випадку це мільйони громадян, а також сотні релокованих підприємств на інші території. Я дуже дякую за організацію цього заходу і за ініціацію взагалі ряду таких заходів шановному пану Олександру, а також Національній асоціації адвокатів України, оскільки питання транскордонного виконання, воно в нас дуже мало досліджено і недостатньо законодавчо врегульовано, скажімо так, да? Тому про це потрібно говорити, і я маю надію, що сьогодні наші шановні спікери з іноземних країн нададуть нам досвід, і ми зможемо його врахувати навіть в майбутніх ймовірних законодавчих змінах. Асоціацію приватних виконавців України сьогодні в нас представить наша чарівна Марія Фесик, а також великий професіонал в справі примусового виконання рішень. Вона більш детально зупиниться на проблематиці, з якою ми стикаємося, а також поділиться, можливо, якимись кейсами з роботи стосовно виконання транскордонних справ чи розшуку цифрових активів. Я ж всім бажаю плідної дискусії, ми дивимося, навчаємося і маю надію, цей захід сьогодні буде дуже корисним для всіх. Дякую.
Thank you, Oksana. For our next welcome speech, Chair of Insolvency Agent Association of Ukraine, Олександр Бондарчук. Happy to see you. Олександр Петрович, вам слово.
Дякую, Олександр. Для перекладача Національна асоціація арбітражних керуючих України і Олександр Бондарчук. Дякую. Вітаю всіх учасників. Дякую пану Олександру за запрошення. Ми останнім часом багато часу приділяємо саме міжнародним трендам і намагаємося пов'язати з національним законодавством про банкрутство. Головна ціль процедури банкрутства в Україні за умови збереження прав як боржника, так і кредиторів все ж таки це підвищений стандарт забезпечення можливості погашення наявних кредиторських вимог шляхом пошуку активів та наповнення ліквідаційної маси. Весь описаний шлях дій в процедурі відновлення платоспроможності боржника приводить до проведення арбітражним керуючим великої роботи щодо формування переліку активів боржника та подальшої реалізації цих активів на найбільш вигідних умовах для всіх учасників процедури банкрутства. На жаль, наше законодавство щодо транскордонного банкрутства в Україні фактично не існує. І фактично пошук активів для арбітражного керуючого в сучасних умовах є основним завданням, одним із основних завдань арбітражного керуючого, направлених на досягнення реалізації головної мети процедури відновлення платоспроможності боржника в цілому або максимального задоволення кредиторських вимог. Варто відмітити, що останнім часом дуже швидко і дуже цікаво формується судова практика в частині притягнення до субсидіарної та солідарної відповідальності керівників підприємств, банкрутів та акціонерів або кінцевих бенефіціарів. Це такий додатковий інструмент, який застосовується в процедурі банкрутства для реалізації головної мети – наповнення ліквідаційної маси. І практика останнього часу доводить можливість приховування активів боржником, в тому числі і за кордоном, до початку процедури банкрутства. І дуже часто це саме зі сторони керівника або засновника товариства, підприємства. Ми бачимо такі спроби. Аналізуючи проблематику пошуку активів, неможливо сьогодні ігнорувати цифрові активи. І зараз очевидно, що Україна знаходиться на етапі формування та започаткування механізмів пошуку цифрових активів. Тобто Україна стосовно цифрового активів не пасе задніх, законодавство у нас і вже є, і воно там поступово розвивається, але ще явно недостатньо для повноцінного функціонування стосовно інших типів активів. Тобто для нас, для арбітражних керуючих, для процедур банкрутства, питання пошуку цифрових активів це дуже цікавий напрямок, який нас інтересує, особливо в банкрутствах фізичних осіб, які також можуть приховувати такі активи, а також в банкрутствах підприємств для пошуку активів фізичних осіб, яких притягають до відповідальності. Так. Крім того, на сьогоднішній день стрімким темпом запроваджуються механізми легалізації клієнтів на світових криптобіржах. Тобто поліпшуються можливості для пошуку клієнтів з криптоактивами вже по всьому світі. Тобто посилення процедур комплаєнсу, фінансового моніторингу, ідентифікації клієнтів. В світі ще існують сірі біржі і ноунейм кошельки крипто, але ми бачимо, що всі великі біржі, всі найбільші біржі, всі найуспішніші біржі сьогодні посилено вводять процедури комплаєнсу, фінансового моніторингу. Я неодноразово наголошував на різних публічних майданчиках, що підвищення кваліфікації арбітражних керуючих – це одне із найважливіших завдань для Національної асоціації арбітражних керуючих України. І тому наша асоціація вкрай зацікавлена в організації і проведенні подібних заходів, які для нас є освітніми фактично. І маю надію, що ми отримаємо сьогодні як теоретичне знання, так і практичні рекомендації стосовно нового, але дуже швидко захоплюючого світ виду активів, цифрових активів. Ще раз хочу подякувати за запрошення. Маю надію, що сьогодні буде ефективна і дуже цікава зустріч, і ми зможемо напрацювати якісь рішення або напрямки рішень для саме застосування в українських процедурах банкрутства. Дякую, колеги.
Thank you, Alexander. Always we are very glad working with National Association of Insolvency agent. We are working close all times. So for next speaker, I want to introduce Maria Fesik, private enforcement officer Ukraine. So, Maria, please.
Good morning, dear colleagues. I wonder about technical notice if everyone see and hear me, right? Okay. I'm a little bit sorry for my English because it's not so perfect as I wish it could be. Nevertheless, I'm trying to do my best in English, and I will tell a few words for our appreciation of your interest and your attention. You know that it's almost 3 years of great war in Ukraine, and we have some troubles in our daily activities, of course. We have many assaults almost every day in all of our territory of our country. Nevertheless, we are dealing with the procedure of enforcement, of legal enforcement. We deal with it, we cope with it, we are working. The economics of Ukraine is working, and also there are some spheres, even when we see some arisal points. Of course, it's not very simple and easy nowadays to do it, but we are all very interested in our sphere, and of course we want our sphere doing the best. I should admit that in Ukraine there are private enforcement officers and public enforcement officers nowadays, and in fact we have a mixed system of legal enforcement procedure. In fact, both public and private enforcement officers are almost entitled by the same authorities, but there are some specific that private enforcement officers sometimes are more moderate and more interested in the procedure because we have some advantages. There is much less pressure in our daily professional routine, and the pressure of the state system, I mean. And of course, the only person who is reasonable for all the actions and decisions in our professional activity among the private enforcement officers society is himself or herself. We have quite great variety of instruments for seeking official information about our debtors. For example, we are officially entitled to have access to the information about the bank accounts of the debtor, and it is the official information, certainly. Also, we have some information of the movement of funds and transactions on these bank accounts for the specific period of time we wish to have it for. Also, we have some information about debtors' deposits agreements, agreements on provisions, debtors with individual bank safe deposit box, some information about real estate, about lands, about vehicles, about other property of our debtors. And of course, there is some modern change in our legislation that there are some property like cryptocurrency. But nowadays we don't have great practical instruments in Ukraine to find those property of our debtors in official procedure or also in unofficial. And the procedure of getting of all the official information about our debtors is quite useful and simple, and it is specific information because only the private and public enforcement officers are entitled to get it. And we have very modern systems and sometimes quite modern state registers For example, we work with the help of our automated system of enforcement proceedings that works all around our territory of our state. And I should say that our state registers are actually database services, and obviously all the advantages of our state systems are great working only when it deals with debtors who live instantly in Ukraine, who are citizens of Ukraine or who are residents of Ukraine. We carry and carefully work with our main law in our enforcement proceedings. It is law on enforcement proceedings in Ukraine, but I should admit that it doesn't have a special rule of law that provides an opportunity for enforcement officers, public and private, both to claim for the enforcement procedure in other countries, either under procedure of the Ukrainian resident debtor or a case of court decision under non-Ukrainian debtors. Nevertheless, the time is already now, and there is a ministry instruction that provides the procedure of international agreements enforcement in the sphere of civil cases that concerns service of procedural documents, getting evidence, and legal enforcement procedure. This legal act regulates the procedure of legal enforcement procedure and recognition of Ukrainian court decisions abroad. By this legal act, there is a step-by-step instruction that provides that claimants asks commercial or civil court of Ukraine, which has reached a decision, confirmation of this decision. After this procedure, the Ukrainian court applies all the documents to Ministry of Justice, and the Ministry of Justice provides a special application to the central state authorities of the country of residence of our debtor for obtaining the permission of enforcement in those states. Also, I should admit that there is a special procedure of entering Ukraine and entering and cooperating of Ukraine with the countries of European Union. And in our professional activity of our colleagues, we also have some very successful cases when private enforcement officers of Ukraine has claimed to foreign courts, and there has been reached a decision for getting some activities from our debtors. In fact, I should say that we are all very interested in this procedure, in the procedure of legal enforcement of under debtors who has residence of Ukraine but now living abroad because of war or because some other circumstances that are with which we are dealing now. So that we are happy and do appreciate the experience we want also practice in Ukraine, and we will be glad to hear some practical advices and spare your experience. Thank you for your attention. I was trying not to be a very long time speaker today because I'm one of the first, and I tried to tell about some specification of Ukrainian court enforcement procedure.
Thank you, Maria, for wide information about Ukrainian procedure. So our next speaker is experience for trans-border enforcement and new European project and new experimental cooperation between advocates and enforcement officer in European Union. Will talk our next speaker, our colleague from Italy, Massimiliano Blasone.
Morning.
I want you to speak. Nice to meet you, Massimiliano.
Nice to meet you too. Thank you, Mr. Chair. I'm very glad to be here. A big thank to the Ukrainian Bar Association for the kind invitation. So I will speak about cross-border enforcement and investigation. And firstly, I will try to share. Okay, you already prepared, sir. Excellent. So let me introduce my presentation with brief preliminary considerations. Cross-border enforcement of claim has gained, as you know, growing importance over years. International trade has steadily increased, and number of people living outside their native countries continues to grow. So recognition, automatic or not, of foreign judgments save time and litigation costs. And there is no need to litigate in the same dispute between the same parties in a different state's court. However, to obtain a practical result equivalent to what which would be obtained if a debtor had fulfilled her obligation, is necessary to enforce the title in other foreign country according to its rules and with the aim to be satisfied with the sale of the debtor asset, goods or credits, and assets found in another country. For this reason, also the cross-border enforcement is strictly related to the research and the discovery of the debtor asset. Although they have many similarities, European enforcement systems are different from one another, and enforcement is carried out by different subjects in terms of role, function, and qualification. Following the definition of the European Commission for the Efficiency of Justice, surpassed by the Council of Europe, we can find international macro category, named enforcement agents, in which are included all professional, private or public professional, from judicial officer and other kind of professional around Europe that carry out the enforcement proceeding. And so when we'll talk in my speech about the actor of the enforcement procedure, I will refer in general way to this professional, to the enforcement agent. So as you can be prepared, Alex, the main way to obtain information about debtor and their assets is through registries and databases. Needless to say that countries do not share the same types of registries and not the same types of data. We can find around Europe public registries or registries with access granted only to enforcement agents, sometimes with only an enforceable title, or sometimes also without it, when it's provided below the attempt by a judicial officer, by enforcement agent, of amicable data recovery. We can find registries on paper, accessible online, one click, or register of debtors subject to enforcement actions. Some countries, the Czech Republic, Hungary, Estonia, Austria, Netherlands, and Belgium, or unitary asset registries, only one in Europe, in Latvia, and also registries with specific information on about of data, of course, not only in one register and not only in every country. So address and civic status. I summarized all the informations, social security, bank accounts, real estate, cars, salaries, company shares, pledges, tax reports, debts, GAN. In Serbia also Western Union transactions, links on movable assets, VAT transactions, and also in Georgia online casino accounts and electronic wallets. So in the next slide, I summarized also our source, other source of information like strengthening of assets obtained from data on request of enforcement agents, There are also sanctions for failure to comply with this obligation, because in some country, a debtor may be arrested for a short period of time in case of failure of information, like in Estonia, or the failure to provide information may be entered in a register, like in Germany, or a fine may be imposed on them, like also in Germany, but also in Finland, in Cyprus, Denmark, Czech Republic, and also in Thailand. In other cases, a criminal litigation may be initiated against the debtor to impose a criminal fine, like in Italy. Also, third-party obligation to provide information, because in some jurisdictions there may be a general obligation on third parties to offer their cooperation with enforcement agents. It includes provision of information. And more generally, creditors may have useful information about debtor and their asset as a result of their relationship with debtor. I also included the European Account Preservation Order, because, as you know, there is provided by EU regulation. It facilitates the freezing of a bank account from a court of a EU country in another EU country, but creditor can request to the court to obtain bank information from competent authorities in the EU country of enforcement. So it's also a source to know where debtors has his her bank account. And in Italy, the next slide, I summarize what happened in Italy. Before 2015, the judicial officer only could, only after the foreclosure had failed, to ask the operators of public databases for information. And since 2015, the creditor with an enforceable title and a servant notice to comply, because by us it is mandatory to start an enforcement procedure with a servant of a notice to comply. But before starting the foreclosure, creditor was able to ask to judge for authorization to have information from the public database by means of judicial officers, and also by means of a lawyer in case of failure of functioning of the connection between the database of judicial officers and the public authorities. Currently, since 2022, a creditor without any authorization of the president of the court is able to ask for information to the judicial officers, and they are able to connect immediately, directly to the database, and have a lot of information, because they have the connection with the database of public administrations, tax authorities, and social security institutions. So a creditor is able to know the bank accounts, employment reports, pension, and real estate, and this contracts. So a lot of information. Analyzing this data, in my opinion, the space of activity for a private investigator in the case of cross-border enforcement of searching for assets to be foreclosed is reduced to cases in which enforcement agents have limited function or limited access to information from databases, or also in case where waiting times to obtain information are very long, or the costs are high. For the reason, in the case of cross-border enforcement, in my opinion, it's essential to make use of experienced professionals in the country where the research must be carried out, and then the foreclosure must be carried out. Because in this way, the enforcement professional is able to advise on the best way to carry out the research. So if you can please share, change the slide. We can see an example of enforcement plan, because usually an enforcement, a cross-border enforcement plan puts the search for asset in the first place, and only then the other steps. We start generally with a search of data asset, and only then we drive it to have an amicable debt recovery. And then the other steps, preparation of possible title, and starting the enforcement procedure. Why amicable debt in second steps? Because if you know that debtor has or not assets, you will be able to do a better agreement for your creditor client. So in any case, all these steps require reliable and specialized professional. And in the next slide, I would like to share an example of this professional, because if you try to click on the logo, maybe we'll start the video, maybe not, and no, maybe not, because okay, it's an example. Connex is an example of European collection and enforcement network with professional. Maybe I will try later to start the video, but I don't want to interrupt the presentation. But in any case, it's an European example. Another kind of example is Leila. Leila, in this slide, I would like to change the perspective of the search, because we are talking, of course, about the search of asset to foreclose. But here, I would like to introduce a way to search for assets already foreclosed, in particular of assets to be sold through judicial auctions around Europe. Recently, 2 years ago, EU started with a project. Now is implementing it, and a project of a multilingual pilot platform where information about foreclosed assets to be sold across Europe is reported with related national regulations. And with aims to improve the effectiveness of the judicial auctions around Europe, and also to give to the user verified information about the asset and the rule of the tender and of the auction in general. So Leila is a portal to search for judicial auctions around Europe, and the data are integrated with the data of 7 countries, the auction data of 7 countries, now currently Italy, Latvia, Croatia, Czech Republic, Portugal, France, and Lithuania. And it's free of charge. And a user, if interested in participating in an auction, can be directly addressed to the national platform that posts the sale notice, and take part in the auction from there, and sending the bid and taking part in the tender. Now, I think that if you, Alex, click on the link, we are able to see the platform, because click 2 times quickly on the, maybe not.
Yeah, I now share the screen. Oh, yeah, you can see.
Ecco, yes. So, on behalf of the representative of the Italian Ministry of Justice, Judge Rosario Mendolia, I would like to share with you an example. This pilot platform, it's not ended, it's updated, implemented every day. But here you can find all real estate, mobile assets, and right already foreclosed and to be sold by. If you click on real estate and search on the above, you try to select, and really it's a great example of European connection between currently 7 countries. and you will be able to know all the information, official information from the portal connected from the countries. And so it's an example of search, it's an example of cooperation in Europe, and for sure it maybe a project to create a portal, a European portal, also to carry out the enforcement, the judicial options, but it will be a next step. So I ended my little speech. I would like to only to share with you this information. Okay.
Thank you. Thank you, Massimiliano. We have one question from Maria, as I understand. Yeah, Maria.
Yes, if I can. I wonder if the participants of this platform could be European Union citizens only. And also, my second question is if Ukraine could also join this platform. Who is the holder of this platform, please?
Maria, can you clarify which platform, Connex or last auction, electronic election?
There are two different things. Connex, it's a network of enforcement agents and lawyers around Europe, private network, and I'm Italian partner, and we work with cross-border enforcement. And was an example, but I didn't start the video, but maybe later I will share with you all the video presentation. But then Leila, it's a public portal free of charge created by the European Union. It's a project ended 1 year ago. Was involved as a legal consultant, and I can tell you that all the people around the world are able to select, because it's free. In a couple of weeks, maybe a couple of months, will be totally ended, and all the data will be translated in the national language, because you're able to select your language, also Ukrainian, to have all the information in your native language. But information from the national portals of each Ministry of Justice in the countries. And every cross-border bidder that is interested in to buy, to search for assets around Europe, for now in only these 7 countries, is able to search and to take part in the tender according to the rules of each country. Maybe in the future will be in news, because I think that I can tell this because not a professional secret, but it's maybe only a dream, I hope, that will be introduce a cross-border procedure for a member of the European Union to have a fast procedure to take part in judicial auctions. So a very easy way to send the bid and to take part in the tender. But currently, Leila is a portal for search only the asset. And I suppose that all countries interested are able to offer integration, but it's necessary to talk with the representative of the partners, Ministry of Justice of the 7 countries. And I know that it's an open project, paid from the European Union, but open to the large Europe of the Council of Europe, for the 46 country of the Council of Europe. So no limits about it, but it's necessary to talk, to have an agreement, and to have a part in the next step of the project. Leila 2, I suppose, the name. So
thank you, Massimiliano.
Great, thank you.
Our next speaker will talk to us about international experience of S-RM company for investigate and trust assets for different jurisdiction. Septімус Knoks, well-known international expert in this field. So I'm very delighted for your participation today. And Septімус, please, your part of presentation.
Thank you, Alexander, and thank you very much for having me today. I'm going to try and share my screen in a moment, but just quickly, I work for S-RM. We're an international intelligence and cybersecurity company. We have 9 offices worldwide, and we're headquartered in London. Our team has operated in over 140 countries worldwide, and we speak 45 different languages in-house, which is very relevant when it comes to tracing assets cross-border and around the world. I should say at the outset that I'm not a lawyer, I'm an investigator, and we trace assets in a lot of scenarios. It could be when you're considering litigating, when you're trying to establish whether a party is worth pursuing through the courts, during proceedings to check for dissipation risk and to check the assets are not being restructured while you're going through the legal process. And then finally, when you have an award or a judgment and you're looking to enforce that against a debtor. Typically, we start with very little information, no internal information, so we have to find it wherever it might be. So I'm going to try and share my screen, and hopefully it works. Okay. Ooh, has that worked?
Yes, we see everything works. Thank you.
So what I'm going to talk through is, what assets we look for, what tools we use to find them. I'm going to touch on social media because it's very, very important in terms of asset tracing. I'll provide a case study, and then I'll also touch on human intelligence, and hopefully we'll have some time for questions at the end if there are any. So that's me. There you go. Very smiley. So in terms of the assets we look for, it's worth saying at the outset that every single individual or company is different, and the individual, the size of the debt, and the location of their assets will define which assets we look for. There's a huge variation globally in the type of asset classes you can have access to and what you can find. But the key objective for us is normally one of 2 things. It is to find an asset of sufficient value to satisfy a judgment or an award, or it is to find an asset that provides significant disruption value to an adversary. So for example, that might mean locating key web domains or key IP that you could freeze or interfere with through legal assistance, which would disrupt the operations of an adversary's business. The other obvious example is things that cause embarrassment or nuisance value, so attempting to seize aircraft or vehicles or properties, and that might be to induce an adverse party to settle with you. So here we have the typical sort of the range of assets we look for. The point to make is that when assets move and when they are harder to locate, but those assets, vessels and aircraft, typically there are global registers which can point you in the right direction. Things like real estate is massively variable around the world. So for example, in the UK, one can find very detailed information about property. You can find that there is a land registry, there's ownership information, there's mortgage information. One can even go to the planning records in the local council and find what changes someone has made to the house. Have they extended it? Which architects have they used? You can really get a lot of information. That could contrast with somewhere like Turkey, where it's very hard to get a similar level of detail. You can locate a property, but you can't locate its ownership. And it's the same, say, for company information. If you look at somewhere like Germany, it's very hard to get detailed company information. But in the UK, again, it is pretty forthcoming. So there's a huge amount of variation. The other thing is that a lot of jurisdictions require local ID or local or being local to access that information. So an example of that would be in Portugal, where a lot of the records are accessible, but you require a national tax number to do so. So if you don't have that access, you're not able to do it. As a firm, what we do as well, we have, as I say, a veritable United Nations of employees, but we also use global aggregators of data, which provide an insight into assets at a high level, that then allows us to drill down into them. Obviously, the objective is always to find the underlying document, to find the piece of paper at the end, because we're always looking to work in coordination with our legal partners to reach an outcome and to potentially adduce our findings as evidence. It's also worth recognizing that in some jurisdictions, the information exists where it doesn't in others. So a rather strange example is that Saudi Arabia now has a register of camels as of 9 months ago, which are obviously high value assets. The UK does not have a vehicle register. In the US, you can identify vehicles. So when you're thinking about asset classes that you want to track down, it's not simply the case of knowing that an individual has those assets or a company has those assets. One must know whether those assets are also documentable and evidenceable in that particular jurisdiction. So where do you find information about those assets? Well, it's very, very broad, and the approach you have to take is normally piecing together fragmentary information from a lot of different sources. So I've touched upon some of these already. But in say a country such as worldwide, again, there's huge variation, and there's know-how in how to do these things. So Malta has a shipping registry, but accessing the Maltese registry requires phoning it up, speaking to people, requesting the right information. It is the same with the British Virgin Islands. For corporate information, you have to submit requests for the information in the right way to obtain the information you need, and even then, it might not give you the full picture. So you have to collate all these different records to build up a picture of an individual's asset or a company's asset position. And the clues can be in all sorts of different places. So for example, one of the things that is common among wealthy judgment debtors is their eagerness to flaunt their wealth. And this comes in many forms, but it could come in the form of providing profiles to architectural or lifestyle magazines, where you might find information about the interiors of their house, the artwork they own, their movements, even their use of private aircraft. In recent years as well, it's worth mentioning that the public record, as we call it, so all possible available information in the world constantly changes. It expands and contracts. So one day is very different from the other, and an example of that is that Dubai has a land registry like many other countries. However, recently it went offline and it's no longer possible to use. So then you have to think of another way to find that information if you need it. So a really crucial thing is staying on top of this change of information. On the contrary, Dubai recently, in the last year or so, or 2 years, made a lot of its onshore court records accessible. So, sometimes you lose a data point, but sometimes you gain one over time. I'll get onto social media, which is a very important aspect of this. But there are two other elements I'd like to touch on first. One is satellite imagery, which is something that, for most of us was something out of spy films in the 1990s and early 2000s, zooming in on a property or whatever it might be. Nowadays, it is possible to purchase commercial satellite data at a commercial rate, so you can see what's going on at a particular place at a particular time. And we have used this to demonstrate that assets are being used and are active in very remote places. So you no longer have to get in a car and go look at what's going on there. You can quite literally point a satellite at it. The other element that is increasingly common in our investigations is leaked data. So that means information that is leaked online, either by hacktivism or in error. And that is a very, very useful tool to sometimes gain very insightful information about the operations of companies, of assets, and even states. And I'm sure people on this webinar are familiar with some of the high profile leaks that have come out. I mean, one that springs to mind is relating to the leaks of delivery services, addresses, and people's contact details, etc., relating to delivery services. While that has not much use to many people, that obviously provides an indication of people's properties, of their use of them, who's there, all those sort of things. So social media is probably the biggest development in asset tracing investigations in the last 10 years. While that sounds slightly unusual, I mean, we spend a lot of time looking at TikTok, at Instagram, at Strava, the running app, Google reviews. They provide indications to lifestyle, to patterns of movement, asset ownership. And typically it is not the wealthy oligarch who has a TikTok account, but it's his cousin or it's his employee. And I'll get onto an example of this later, but you have to cast the net very wide and work out who knows this individual and who's likely to enjoy use of their assets or move in their social circles, and make sure that they're included in your investigation. The wider you cast the net, the more likely you are to have success, as a general rule. So here I thought I'd give two fairly light-hearted examples of how you can combine all these tools, which is what you have to do, and data points to identify assets. So we had a case in the Middle East where a judgment debtors had set up an Instagram account for their dog, which again is not that uncommon for people to do this. Through looking at this account, it was possible to identify a property where the dog was living. We then worked out where this property was by visiting it and finding the apartment block, working out which floor it was on. Once we had identified the unit, we were then able to pull the title deed and prove that this individual was the owner of the property. So from the Instagram account of a beagle, we were able to locate a multi-million-dollar asset. Another example of a similar thing is we were tracing the assets of an individual in the UK, in London, and a family member of theirs was posting TikTok videos from the roof of their house, which overlooked a park in London. And the property overlooked a road, which overlooked a set of trees, and those trees it was possible to work out roughly where this property was as a result of the trees. So we then quite literally got on a bike, cycled from our office to the park, worked out the trees, and then used geolocation to work out exactly which property the photo was taken from, the TikTok was filmed from, and then retrieved the land records. The additional step there, which, as I mentioned, in the UK, it is possible to get planning records. And in this instance, the property was actually owned by an offshore company. But the submissions for the planning registry for an extension of the property had been signed by a member of the family, thus showing that they were the beneficial owners. So the point here in these two examples is that you have to marry up multiple different methodologies and multiple different data points to identify evidence of asset ownership. So here is an example of a real world example of what I'm talking about. And this relates to us attempting to identify the ownership and locate a specific vessel. On the left is the first and only clue we had that this individual who had owed multi-million-dollar debt to our client. There was a photo of an office party essentially on their yacht, and on the left you see a photo from this event that was taken by one of the employees, and you notice a fairly distinctive table and chair setup on the front of the boat. So most yachts are available for charter at all times, and the second photo shows us how we found that specific vessel on a yacht chartering website. So once you have that, you then need to locate its ownership. In this case, it was in Malta. So I made a request to the Maltese registry, and we located the specific vessel. Then we used Instagram many hours of scrolling to identify where the vessel might be. So we searched for Greek islands, and there on the picture on the right, you can see the actual vessel. Again, there was another element to this where there was a pay dispute between the captain of the vessel and the owner in French court, which provided another data point, and you can see the ship was actually built in France, which showed the owner of the vessel, individually rather than through a corporate entity. Well, the individual who owned it, I should say, and the beneficial owner of the holding company. So that's a very small example, but this process can take a very long time. I mean, there are tools, increasingly, AI-driven tools to search through data, but the human touch is always necessary to spot these things, and then work out a way to get to the answer you need. And speaking of humans, that brings me to the other aspect of how we track down assets, which is human intelligence. Human intelligence is not James Bond. It's more thinking of individuals, wherever they might be, who might know a piece of information about the person or company that you're interested in. And again, it's very broad. It could be an academic, it could be a neighbor, it could be the plumbing company that services a property. It could be a former employee. It's very broad. The important thing here to mention here is that these people aren't silver bullets. They don't provide, massive dossiers of information that you need. They normally provide, again, a small piece of the picture. And human intelligence should always be an input into the investigative process, not an output, because what we are trying to find is documentary evidence of asset ownership. And of course, an individual will normally tell you something. They won't give you a piece of paper that tells you what you need. And the way we go about finding these individuals varies, again, from a case-to-case basis. So sometimes you will, we have our own company network. We have 400 members of staff. We also have an advisor network who helps us out. We also have local agents in most countries in the world, but we also identify unique sources in each cases, and we'll contact them ourselves. And finally, just as again to really illustrate what it is we do, on the right is a picture we took of a series of documents that we had obtained in the course of an investigation. That is a truck filled with wet paper, for avoidance of doubt. And on the left is what we produced at the end, which is a chart of ownership for an individual who had interest in assets across Russia, the Netherlands, Cyprus, and some other geographies which are covered up by the picture. France, you can see down there. Vehicles, property, all corporate assets. So what we do is we take unstructured, fragmentary information and turn it into something that is usable and admissible and can inform your legal strategy, your approach to dealing with a judgment debtor, and hopefully at the end of the day, returning assets to the people who are owed the money. So that's the end of my presentation. I'll stop sharing now. I don't know if anyone has any questions. I'll be pleased to answer them.
Thank you, Septimus. Great presentation. And I just remind from movie Advocate's Devil or Devil's Advocates, my favorite wisdom about vanity is my favorite theme. It's always support us working with debtors and when we search assets. So I want to invite our speakers for media photo for a few seconds for Ukrainian media. Just smile and all ready for media. So Septimus, thank you very much for your experience, and we continue our speakers and presentation and follow from the logic of enforcement and insolvency procedure after law procedure and enforcement in different jurisdiction after investigation and search of assets. We continue speak about expertise and opinion and financial documents, and I want to pass word to Parker Russell, our next speaker. Jason Parker. Jason, do you hear me?
Can you hear me now?
Yes, thank you.
Okay, good.
Yeah.
It's my show now, is it?
Yeah, so I show your presentation.
Okay.
Share. Oh.
Okay. Good morning, everyone. I'm Jason Parker. I'm one of the managing partner of Parker Russell. We specialize in forensic audit work in the UK, and we have presence in over 80 countries. So we operate as a network, and all these offices around the globe are member of Parker Russell International. Most of the member firms under the Parker Russell brand, and we utilize the same resources. We have the same skill sets and highly regulated by the regulator in each individual countries. Today, I'm going to give kind of information about the Proceeds of Crime Act 2002. Now, my presentation will focus on the legal framework of asset recovery rather than, I will not go into specific how we do the work to recover the asset or identify the asset, but I will just kind of try to give you some indication about how the identify hidden assets in the UK. Obviously, the presentation is not only restricted to UK hidden asset recovery, but also brings in the international aspect of the proceeds of crime that currently has been happening. So to give you some understanding, okay, today I will be talking about the Proceeds of Crime Act 2002, also known as POCA in the UK. And in the UK is legislation designed to recover the asset proceeds through a criminal activity under the Proceeds of Crime Act 2002. This is the basis that all the investigations being launched either by the local government or by individual in order to try to recover the assets that it is illegally been sourced or hidden. Now, the Proceeds of Crime Act 2002 provides legal framework in the UK for recovering assets obtained through criminal activity, and it has key aim basically deny criminals of their financial gains, deter criminals' activity by targeting profits of the crime, and disrupt organized crime, preventing criminals from benefiting from their illegal activities. Now, what are the hidden assets in POCA proceedings? Okay, now for the sake of presentation, okay, even though I'm referring to POCA most of the time during my presentation, globally, okay, let's assume that something similar that you have in your home country, similar to POCA, okay? Now, back to hidden asset recovery under the POCA rules and regulations. Now, the hidden assets in POCA proceedings usually occurs when assets suspected to have obtained illegally and cannot be accounted for. In case like this, the defendant must cover these hidden assets. And it is also true that if the court suspects the defendant is living in a lifestyle that is only possible with the use of hidden assets. Now, hidden assets in POCA cases, proceeds are often kept intentionally concealed and are not fully disclosed. This is generally done to avoid detections and eventually confiscations. Identifying and recovering these assets is a fundamental aspect of the Proceeds of Crime Act process. Now, these assets can take various forms and often kept intentionally concealed or not fully disclosed. This is generally done to avoid detections, eventually confiscation, identification of and recovery of following. Okay, so the following are the example of hidden assets that we basically investigate. So, for example, undisclosed bank account in different jurisdictions. Okay, even though it's becoming more and more difficult now to open a bank account, criminals still able to open bank account in different person names, different structures, and so on and so forth. Offshore accounts is quite popular way of hiding assets. Okay, it is uncommon for individuals to transfer their ill-gotten gains to offshore accounts in tax havens or with strong financial secrecy law. Now, in the past, people park their assets offshore. The main intention is to avoid paying taxes, okay? But they now moved on, okay? They want to hide the asset at any cost. The taxation isn't the main driven factor of hiding the assets in this day and age. And real estate, quite common for, the criminals to invest their illegal income into real estate, okay? The objective is to buy the asset, sell the asset, and legitimize the income that generated through illegal investments. I mean, the UK is a hot place for real estate that has been sourced and purchased by the criminals. The next one is the business interest, okay? Creating a structure that is very complex for the regulators to understand, okay? Creating so many subsidiaries, different locations, BVI, Marshall Islands, name fews, intended to conceal the transaction. So the more subsidiaries within the structure is more difficult for regulator or individuals to identify the hidden assets. The high value assets, criminals will often look at invest in luxury items such as expensive cars, jewelries, arts, okay, and small items with high value, okay? That is a way of concealing the hidden assets in this day and age. The cryptocurrency is the one that currently has been happening quite a lot. We're currently investigating at least 5-6 cases where the cryptocurrency has been used to move assets in different jurisdictions, and it's not easy task to identify the source and direction of the crypto assets. And we are assisting with many cases involving cryptocurrency cases. So the trust and other assets, okay, now trust in nature, they are perfectly legitimate vehicle to create, okay, but unfortunately they've been used for different reasons, okay. If you look back for 10-20 years ago, trust was a way of protecting your assets from liquidations, okay, or mitigating your tax liability within the legal frame, but now it's been used for different reasons, okay, and the criminal are using more often trust to protect their assets, but most of the jurisdictions are communicating with the other jurisdictions, so it is again becoming quite difficult for the criminals to hide their assets using trust setup. I'm not going to go in detail of each of these items, okay, but if any questions that may arise, I'm more than happy to address these questions later on. And obviously cash is the one of the biggest means to hide assets, okay, but then again it is no longer, you cannot walk around with a briefcase full of cash and trying to buy assets. Most of the jurisdictions are refusing to take cash to sell the items. Even if you are able to find someone to take cash in exchange for disposing assets, it will be very difficult for the person receiving the cash to use that cash to invest or reinvest the proceeds from that activity. Now, how to find hidden assets? Okay, that is a quite difficult part, and that's why it makes people like us to assist with the parties involved in hidden asset litigations and recovery. Now, during the POCA proceedings, there are a number of key techniques utilized in order to locate, uncover hidden assets. POCA specialists will look into identify these assets, prove connections to criminal activities. So you have to identify the asset and then prove the connections that it is it is related to criminal activity. So only not identifying the asset, but also difficulties trying to prove that it is put together by criminal activity means, okay? Defining hidden assets in the context of POCA, proceeds of crime act, proceedings or other asset recovery efforts often involve combination of investigative techniques, financial forensic, for example, and that's where our specialty lies. We involve in the financial aspect of the hidden assets procedures, okay? And our expertise, our knowledge of the industry, our knowledge of the structures. I mean, one of the main services that we provide to people at large is to help them to structure a tax-efficient structure involving different jurisdictions. So we're utilizing this knowledge of creating this structure, okay, not for criminals, I must highlight here. We do this for legitimate reason. So that gives us a lot of expertise in that field to undo structure created by criminals in assisting us to identify the hidden assets. Now, here are some basically crucial considerations to keep in mind when identifying the hidden assets under the POCA, okay? Now, concealment. It is likely that criminal will attempt to hide their ill-gotten gain by placing them in a name of third parties that you've been hearing from the previous panel members, that usually assets been placed in different individual names, okay? And then different individuals are fronting these assets as the main, claiming that they are the main owner of the assets. And non-disclosure, okay, when individuals are asked to make tax declaration, they do not disclose these informations that they do have assets and in a different jurisdictions. Now, non-disclosure usually also work with the divorce cases, because we are involved in many divorce settlement cases involving different jurisdictions. And if the parties, defendant is not disclosing all his assets, then we are getting involved in those proceedings and litigations, and then trying to help the party to identify the hidden assets that may be in different jurisdictions. Asset tracing, it's been mentioned earlier by one of the panel members that the process of assets tracing is comprehensive, so it's quite difficult task. Following the money trial, determining the true ownership or value of any hidden assets is vital. Now, as I said, the asset has been placed in the hands of a person that is not the real beneficial owner of the assets. It is us to prove that the beneficial owner is not the legal owner of the assets, and there are techniques to identify these procedures, okay? So the first one is the forensic accounting. Now, this process involves in going through all the documentations, okay, legal documents, financial documents, registered in different jurisdictions. Now, it is much easier for us to identify these items because we are part of the Parker Russell Global Network, and we coordinate with all our members globally. And if the, for example, if the task is involved in Malta, Cyprus, we have presence in these jurisdictions, and they are part of the same accounting firm, auditing firm that assists us with identifying these assets, rather than trying to rely on third-party agent in the jurisdictions. So it makes our success rate much higher compared to using subcontractors or consultants in the jurisdictions. And the other technique of asset tracing is basically talking to individual involved in the litigations or be subject to criminal investigations. Like you interview, you ask questions and trying to analyze what they are saying, and use this technique to identify the assets by analyzing their responses to it. Digital forensic, okay, in this day and age, digitalization is quite important. Facebook, TikTok, and the criminals usually trying to make their stuff look better. They do TikTok movies and films and so on and so forth, not necessarily in their name, but maybe in the different person's name. But if you put the jigsaw together, you may be able to identify who is the real beneficial owner of the assets, and work with international authorities. Now, obviously, when it comes to hidden asset, you have no choice. You need to communicate with the international authorities within the jurisdictions. Okay, so even if you identify the asset that is, for example, the asset is in Malta, you have to communicate with the local authority in order to have cooperation and coordinations in either recovering the asset or putting freezing order against the asset that the criminal cannot dispose it by the time the case is being concluded. There's also restraint orders that the court can grant, okay, under restraint orders. This can be effective measure to prevent disposal of or transfer of potential hidden assets, so those making available for potential forfeit in the future. So once we identify the asset and we coordinate with the international authorities in different jurisdictions, we may ask the authority to put freezing or order against the asset, restraining order against the assets, until the case has been heard and dealt with. Confiscation order, that is another way of stopping the criminal to dispose the asset. Okay, we help the authorities, we provide our reports and report regarding the hidden assets, and ask the authorities in the jurisdiction to impose confiscation order. When hidden assets have been identified and linked to criminal activities, the court can issue confiscation order. Now, the premises of confiscation order is force individual in question to either surrender their assets or pay equivalent value. Now, this confiscation order, obviously you have options. Either you return the asset, or if the asset isn't there, you have to pay similar value to the parties claiming the asset. Now, sometimes criminal recovery is not possible, okay, for a number of reasons, and then civil recovery might be the solution to recover the hidden asset. Now, it may be possible for a person not even confiscate or crime to have the assets confiscated. In such a cases, the burden of proof will often be lower than the criminal proceeding, so potentially making it easier to seize asset by way of the civil recovery. And then the other possibility is asset forfeiting. Once the hidden asset have been identified and linked to criminal conduct, they are eligible to be seized. Okay, obviously, you have to coordinate with the multiple jurisdictions to be able to impose these restrictions and confiscations and restraining order. The asset recovery method used, POCA, as I mentioned earlier, confiscation order, civil recovery, asset freezing order. Okay, now the law enforcement and can freeze suspicious bank account. For example, if we believe that the criminal or individual or the company involved in criminal activity, we will make an application to court in the jurisdictions that the criminal are operating and ask the court to impose freezing order against their bank account. Okay, or properties, or if they got yacht, if they got private jets, we can ask the court to put freezing order on the items in questions. Now, in the UK, it's becoming quite a common exercise. Okay, unexplained wealth order. Okay, now this is very powerful order imposed by the court. Okay, on individual, asking the individual to explain how did they come into this wealth. Okay, so for example, if an individual filing tax return showing £100,000 a year income, when the individual in questions is living on a luxury life that requires £2-3 million a year to support his lifestyle. So if the individual cannot explain this, how he came into this, then the court has right to impose restrictions and impose unexplained wealth order. If the individual are unable to explain how did they manage to acquire the assets, then the court will seize the assets of individual that is currently enjoying the wealth that he currently is in. Now, as I said, the technique in using finding asset, we talk about the forensic accounting. Obviously, that involves in analysis of the transaction, the bank statement, as I said, the ownership of the assets that claim to be owned by the individuals, and it may involve in multiple jurisdictions. We talk about the unexplained wealth order. International cooperation is quite key in this kind of investigations. Many hidden assets are concealed in offshore accounts of foreign jurisdictions. And I will be talking about a few cases that involve international cooperation between multiple jurisdictions, and the confiscation order we talk about, and civil recovery if the criminal recovery that does not succeed. Now, the penalties and concealing assets. Okay, this is specifically for the UK, but I'm sure the other jurisdictions have penalties for hiding assets, and possibly criminal and possibly imprisonment sentences for concealing the assets. Now, individual code, this is in the UK, hidden assets can face several penalties, including additional confiscation order, prison sentences, and civil penalties. If the person subject to confiscation order but fails to pay, I mean, for example, okay, you get the judgment, you prove that he's criminal and he proceeded from the criminal activities, but he's no longer have these assets and he's got nothing to pay for, the court will impose imprisonment individual concern. And the prison sentence will depend on how serious the case is and how much money is involved and so on and so forth. Now, as we said earlier, okay, now the hidden asset recovery is not going to be possible without the international cooperation between the jurisdictions. And there are certain organizations being created, or it is in existence globally, to enable communication within this group structure, okay? So the first one I'm looking at is the mutual legal assistance. Now, what is mutual legal assistance? Okay, mutual legal assistance is the formal process by which the country requests assistance from another in gathering evidence, freezing assets, recovering proceeds of crime. It is governed by the treaty, convention, and bilateral agreements. So there are a lot of agreements between the countries that assist enforcement, okay, in either freezing assets, recovery proceedings, and so on and so forth. So how this process works in line with the POCA. Now, for example, UK authorities can issue requests for foreign governments, okay? This is done through the normal channels, okay, government to government. Trace and freeze assets held abroad, obtain bank records, okay? Obtaining bank statements and relevant evidence from the foreign jurisdiction. Executive's research warrant, okay? The UK may ask, for example, Italy may ask Malta to execute search warrant on the suspected criminals in Italy or Malta or Cyprus or wherever maybe the criminals are operating from. Now, the UK central authority called UKCA, part of the Home Office, okay, this is also the Home Office also involved in this kind of jurisdictions. And the MLA requests England and Wales currently operating under this jurisdiction. Now, the International Asset Recovery Agreement, there are agreements between the countries under the name of International Asset Recovery Agreement. Now, bilateral and multinational trade. Now, the UK has signed a range of treaties and agreements with other countries that allows for asset recovery, information sharing. Now, there are a lot of agreements that if you look hard enough, you will find these jurisdictions. And when we have filed a claim against the criminals, we use these bilateral agreements in order to enforce recovery freezing assets. Now, the UK has signed a range of treaties, as I said, agreement with other countries that allows asset recovery and information sharing. This includes the European Convention and Mutual Assistance in Criminal Matters and treaty with the non-EU countries, okay? So there are a lot of agreements that is available at your disposal when it comes to enforce asset recovery in the hands of criminals. Now, multilateral incentive. Now, the UK works globally, initiative like Financial Action Task Force and Stolen Asset Recovery initiatives, which promote international cooperation, combat money laundering, and recovery stolen asset globally. So again, this is another, the enforcement authority that work quite closely with other jurisdictions globally. Now, the European Union cooperation, now I'm here referring pre-Brexit and post-Brexit, okay? Obviously, UK is no longer part of the European Union, but the same rules and regulations still applies when it comes to asset recovery. Before Brexit, the UK was part of European Arrest Warrant Organization, and could use European Investigation Order, EIO, to facilitate cross-border asset recovery investigation within the European Union. Okay, so there is European arrest warrant for European countries and a European investigation order that can be imposed on. So these are very, very powerful agreement that impose and work with the parties concerned. Now, the post-Brexit, we are no longer part of European Union, okay? And I think the same applies to Ukraine, okay? That they are not part of European Union, but they could possibly use, post-Brexit rules and regulation where UK now relies on new bilateral cooperation agreement with the UE, individual member states for investigating under POCA. So these agreements often mirror earlier framework, but can take more time and require additional steps for coordinations. Now, as I said, these rules pre and post is similar, okay? But because we are no longer part of European Union, the process is a bit much slower when we coordinate with our colleagues in European Union. The next one is the United Nations International Conventions. Now, the United Nations Convention Against Corruption is called UNCATID, and the United Nations Convention Against the Transaction Organization Crime provides a global framework, okay, for cross-border investigation into hidden asset, money laundering, and corruption. So the United Nations International Convention most probably will be suitable for Ukraine trying to impose the hidden asset recovery and confiscation orders, okay, when it comes to identify the hidden asset that it is not in Ukraine, but it is somewhere else. Information cooperation via police and regulatory networks. Okay, obviously, you cannot keep the police out of these investigations. And in addition to formal legal assistance, law enforcement agency like the National Crime Agency. Now, in the UK, the police, as known as National Crime Agency, work closely with the counterparts around the world through information channels, including Interpol and Europol. Now, don't forget, Interpol and Europol is at your disposal, okay, when it comes to asset recovery and close coordination with these units, with the NCA in the UK, Interpol globally, and the Europol also is assisting these cases with asset recovery. The agencies share intelligence and suspected criminal and financial network, allowing for quicker action to trace and freeze assets before the MLA proceeds can be initiated. So I think communicating with NCA, if you've got evidence that the parties involve criminal activities, etc., I think your first port of call will be National Crime Agency in the UK, and the Interpol globally, and the Europol within European Union. Joint Investigation Team, JITS, this is another regulator, allows UK authorities to work directly with the foreign law enforcement agency on a single cases, okay? So if you've got a single case and you're trying to impose asset restrictions or explore information, Joint Investigation Team allows you to coordinate these activities much easier when it comes to recovering assets. Then we have reciprocal enforcement and confiscation order. Now, under the POCA, the UK requests enforcement for a confiscation order made by the UK court in another country. So the UK court will issue confiscation order, and if the asset is not in the UK, then the UK court will ask the foreign court to impose confiscation order. Okay, now this is not an easy task. Involves the court, involves the expert and specialist to activate or impose this confiscation order on the individual concerned that involve in criminal activities. There is a cross-border freezing order and asset forfeiture. The UK has ability to apply freezing order to prevent dissipation of the assets while investigation or legal proceedings are underway. Now,
Jason, I just remind you about time and remind to our participator, maybe someone have some question for,
Yeah.
we have 10 minutes for question and answer and for discussion.
Yeah, I'm almost, okay. Okay, so you have my, presentation with you, okay? So maybe you can distribute that to all the participants that wish to copy of that manual, if you like, okay? And if I run out of time, I'm happy to stop here and take questions that they may have for me or for the panel. Is that okay?
Thank you for brilliant presentation. And as I see, you.
I mean, sorry, it was a bit heavy-handed. I mean, it was rather be a heavy one, but I think explaining the individual what this asset recovery is involved is quite important. I mean, I had few cases that involve in confiscation orders and involving global jurisdictions, but they can always read that from my handouts.
Oh, great. Obviously, you know, because today in our event we show and going to provide to our participator international experience and show to Ukrainian enforcement officers and insolvency agents and lawyers how it's work in international cooperation. I give a contact first class international expert like you, like Massimiliano, like Septimus, who have experience, many years experience and expertise in this field. Because Ukraine, yes, not part of European Union, but as Massimiliano told to us, we are part of European community, and our have a lot of cases actually now for cross-border insolvency and cross-border enforcement. And of course, our debtors sometimes mixing assets, stolen assets, and use different shell company for protect property from insolvency and enforcement. So just for finalize our discussion, a few words, I want to pass a few words from Massimiliano. Maybe you have some ideas for next steps for facilitation cooperation between lawyers, enforcement officers in Ukraine and European Union. And same question to Jason, to you, for your opinion, next steps between our communities, between Association of Enforcement Officers, Association, Bar Association, and National Association of Insolvency. Next steps for best cooperation and facilitation in these processes. Thank you. Massimiliano, maybe you have some ideas.
Well, thank you. The first step, in my opinion, to improve our professional cooperation, because everyone has his/her experience, and the first step is to share information, to share our way of work of our enforcement systems, and then I think that we can find similar solution to the same, often the same problems and issues, and to improve the cooperation. It's really not only a political issue. I think that already Ukraine Bar Association has opportunity to work with the European country, because in my opinion, Europe already considered Ukraine a member of the Europe, and so we have to talk to like today, and it's the first really step to break all the border, all the barriers, and to work together. But so the first step really to create confidence between professionals, and I think that there is not a great difference between lawyers and enforcement agents. depends from from each country. For example, I'm a lawyer, as you know, and also an enforcement agent because I am a special court list. I carry out the real estate foreclosure representative, my enforcement judge. So there is not a great difference. We are in this field experienced enforcement professionals and enforcement agents when we work in this field. So I think that friendship, professional relationship is the first step to a formal cooperation that we will come for sure later.
Oh, thank you. And as I saw in your presentation about Connex network, one of the Ukrainian enforcement officer wanted to be a member of this open network.
No, it's well, we in every country of Europe we have a partner already. We are 22 partners, and we have only one partner for country, and we already have a partner from Ukraine. But if someone has some problem, something to enforce, data to enforce in another country, it's open because we work together, but everyone is able to select a partner not in another country and to work with him. We are not we are exclusive partner of the network because we share periodically information. We improve our experiences studying each other judicial systems. But every creator is able to select a partner of Connex to work for him, for her in foreign country, and so so it works so, but so we are able to study better problem issues of every country. So I answered so.
Thank you. Jason, what do you think about?
Well, I mean, I think whether Ukraine is within European Union or not, it is in Europe, okay? And most of these confiscation orders and coordination between the different jurisdictions usually operates under United Nation agreement anyway. So I don't think the Ukraine should feel powerless by imposing restrictions on individuals that involved in criminal activities that are hiding assets outside Ukraine. I mean, United Nations International Convention is very powerful agreement involving all the countries literally in the world. And I think, you know, as I mentioned, there are 7-8 authorities globally that Ukraine can work with, okay, and utilize these resources to enforce asset freezing order or recovery of assets. Now, as far as us working together, now like I just said, the Parker Russell involved in many litigations. Okay, we do a lot of litigation support and arbitration on top of helping asset recovery, and we currently in 80 countries, operating 80 countries. They're all fully firm belonging to Parker Russell. The fact that we have these offices around the globe help our life very easy, okay? And we don't need to know every single possible rules and regulation of individual countries concerned, but it does help us to work better through the network, okay? So we are more than welcome to work with Ukrainian lawyers and forensic auditors in assisting them with sharing our experience with them, okay, and possibly assisting them with certain cases that the Ukrainian lawyers and currently undertaken. And I'm more than happy to exchange informations and possibly have a chat on a one-to-one basis if there's any need for urgent case that needs taking care of.
Thank you. If anyone have any question, I have all presentation of our brilliant speaker. So I will send. We have list of all our participators, so we can send it after the end of our event. We will share record on Facebook page of Ukrainian National Bar Association and in LinkedIn as well. So record will be available for all who want to listen careful parts of our events. And thank you for all for your attention and your participation, and mainly Association Private Enforcement Officer of Ukraine, Ukrainian National Bar Association, Clark Foundation of Legal Education, who support us for sharing British law experience for different country and exchange our experience to British law community for all professional between our countries, our areas. Thank you for National Association of Insolvency Officers and Insolvency Agents and Institute of Economical Legal Research of National Academy of Science, who support our academic and scientific researches in these fields of commerce law. So thank you for all. Thank you, Jason. Thank you, Massimiliano. Thank you, Maria, Alexander, and our Oleg Klimyuk for support with interpretation, and Alexandr Bondarchuk, and of course, Oksana Rusecka. Thank you for all. See you on our next event, and please, you be free for looking for our records for our former events about enforcement for digital assets, for international freeze order in September and October. So we'll meet of our next event. Thank you all.